welcome everyone. Glad to have you with us. I've been kind of looking forward to this webinar. I haven't spoken on this topic very much, and yet I think it's a really important topic because if you don't get this right, it absolutely can cause problems with your distribution channel, your sales channel. And you'll see in a moment, it's really one of the first big tasks that you've got in a relationship with a foreign partner. And I was not very good at the beginning of it, but I got better as I continued appointing more and more distributors. I think a lot of you know me, but just to clarify, I was in international sales and marketing based out of London for a number of years. And before that, I was doing sales and marketing for Europe, but based out of Los Angeles in the computer industry. And my job was to appoint distribution for computer products throughout Europe and a little bit in the Asia Pacific. Now, I always used exclusive distributors. I'm going to talk about that because I get pushback sometimes when I do training programs about my enthusiasm for exclusive relationships. So I am a little biased, and you're going to see that I have some slides talking about how to navigate the issue of an exclusive relationship with a foreign partner. But in that case, of course, the contract becomes even more critical because you've got to tie some performance targets to that contract to protect you as well as non-competing products. So that's just another reason why the distributor contracts are so important. So I'm really bringing that experience of working in Europe and negotiating lots and lots of contracts. And of course, the first thing I learned is everyone seemed a little bit different, which we'll talk about a bit as well. And I will admit I'm focused mostly on a relationship with distributors because I had products that needed to be stocked overseas. It would look a little different in the case of a representative or an agent. So I apologize that I'm kind of assuming that most of the interest in the group is going to be on the distributor side. The principles are going to be the same anyway. And so I hope that that's not going to be in any way a restraint on the discussion that we have. As Lisa pointed out, I'll pause now and again to see what questions have come in. We've got a big group, so we're asking that everyone do the questions via chat, but I'm absolutely happy to do the best I can to get you those answers. Needless to say, I have to start just with a real quick overview. This is what we had in the announcement for the program itself, just a little bit about why this is so important. And then I want to move to the topic of MOUs because later I worked for a startup company west of London, and there we started using more memorandum of understandings. I've talked a little bit about that because I found it actually pretty effective as the first sort of relationship. A bit about how to approach the negotiations. It is somewhat of a dance. I think we all know that. I know we've got a lot of experienced people, so you've been through this process. So I hope just hearing my perspective on what I did to negotiate that distributor contract, what the experience was like. There's that bit I warned you about, talking about exclusive versus non-exclusive. And then I've picked out about 5 or 6 topics specifically to go into more detail. And I've actually got examples of clauses that I used in contracts. It's a little wordy on those slides, but I thought it would be helpful for the purpose of discussing those topics to specifically see an example of one that came from our contract. Needless to say, I just have to have the standard slide that says, I am not a lawyer, this is not legal advice. I can't stress enough that anything that you do in this area needs to be done totally in concert with legal advice. And so you're going to see that a lot, that I'm going to keep saying, you've got to go back to a lawyer to get this sorted out. I'm just going to give you my perspective, what I learned from the process, and I hope that helps. So, of course, why do we have contracts? I mean, it's pretty obvious. The first point is just to keep both sides out of trouble. I do think my experience with U.S.-based contracts, or I should say contracts written from the perspective of a U.S. company, they do tend to seem to mostly want to keep the U.S. party out of trouble. So in my case, the exporter out of trouble. I think that you'll find that when you negotiate the contract, it will be pulled a little bit more toward the needs of the distributor as well. But it is intended to protect both. I mean, there are certainly issues such as when is the contract going to be terminated, or what would be the circumstances by which that could happen? And that's a really tough time when that has to be done. I've terminated distributor contracts, and it's never fun. And you need something that sits over you to give you that sort of clarity. And that leads to managing expectations. You're going to build things in, as you know, in your contract that clarify what the expectations are of both sides. What's the role of the exporter in terms of training and sales support and customer support? And what's the role of the distributor? Do you have expectations about trade shows or participation in trade shows? You'll see some clauses might be quite generic, such as best efforts. Distributors shall use best efforts. You might want to take that a bit further and say including, and actually specify some expectation that you have in terms of those marketing activities. Who's going to handle social media? A really huge area right now. Is there going to be website localization? In that case, who's going to be doing that? So these are things you have to discuss before the contract gets signed, and I think that's a good thing, because these are not issues that want to come up afterwards when you've signed some other type of contract that didn't have this kind of clarity, because then it gets very awkward. So I hate to say this example, but it's kind of like a prenup, I guess. You got to get these issues on the table so that both parties understand where you're headed. And as I say in the last point, this is really the first big task. I mean, you've already had all the fun in choosing, because I always found the process of choosing a distributor one of the best activities of my job in doing international sales and marketing. Just the process of interviewing potential distributors, quote unquote, interviewing and selecting them, and then finally when you get to tell the one that you selected. So everyone's on this kind of high, and then you're like, oh, but don't forget, we got to negotiate this contract, or we got to sign a contract. And that's the first thing that's really going to test that relationship between the exporter and the foreign representative. So it's a really interesting time. You can't push the process as much as you want or your boss wants, but nonetheless, it's one of the first big things that you have to do. Now, I mentioned that I started using MOUs in the startup company, and the reason why, let me first just, I think we all understand, but let's be clear. A memorandum of understanding is a much simpler, compact, not as specific, saying we're just planning to kind of work together for a period of time. Ours were 6 months, and the purpose here is to not develop relationships with anybody else. So I'm not planning during this 6 months to actively look for another representative in that market. And by the same token, the distributor's not planning to look for any other product that might compete. And we're just going to do this for 6 months with well, the expectation is that we'll sign a contract at the end of the 6 months. But the expectation could be as well that, this didn't really work out. Our product, the exporter's product, wasn't a good fit for the line of products that the distributor was carrying after all. And so it's an easy way, because there's no sort of, quote, drama in walking away from the MOU. So I can see that. We were a startup, so maybe that was one of the reasons we did MOUs that then moved into contracts. But I can certainly see a justification. So if you want kind of that easy way to start working, but you want a little bit of protection, then do an MOU. You'll see I have still get legal advice. So our MOU was still drawn up by a lawyer. Now, when might you not be able to start with an MOU? Maybe I should have swapped these two bullets. When you use a contract? Well, if right from the beginning you know this is meant to be a long-term relationship, then I don't really see a problem moving into a contract. The other would be that the distributor might just say they're not comfortable with an MOU. And you may also get advice from a lawyer that says for that particular country, the MOU really is not going to have the kind of effectiveness or protection that you need, and therefore you may need to go straight into a contract. So I just put that out there. It was new to me. For the California company I worked for, Western Digital, we always started right away with the contract. But I really did like later, when I experienced working with MOUs, that sort of just starting to have a more formal relationship, but not as difficult as the contract. And the other big thing I have to say about the MOU is there was no difficulty getting it signed. Whereas with the contracts, there was so much always going back and forth that was always a bit of a challenge. So how did I approach negotiations? So the first thing is I always just sent our boilerplate distributor contract to the distributor. Now, obviously, that means that, yeah, we first had to invest in a template that our lawyer did for us. So they created the template that I have to say was pretty U.S. and exporter-centric, meaning most of the concerns were all stated from the perspective of the exporter. And sometimes I might even say that. So when I'd be sent it over, I'd say, now I realize, this might look a little bit US centric. So let me know what concerns you might have. I certainly acknowledge that I'm open to edits. You've just simply got to be. You never know what the specifics are going to be in a particular country where there might be some issue that has to be dealt with that you simply can't have that clause because it's contrary to local law. It might just be that they have a particular point that they're concerned about in terms of, for example, use of intellectual property. Our standard contract said that no schematics to our products will be allowed, that we will not share that kind of information. And very quickly I learned from pushback that just wasn't going to work, that my distributors needed a certain level of local repairability, and to do those repairs, they needed schematics. And so ultimately, we negotiated that out. And for some of my distributors, we actually did, under an NDA, a non-disclosure agreement, did share those schematics. So those are just examples where I didn't see that coming, but in the negotiations, those issues became clear. So essentially, I'd send that initial template. I would kind of be the good guy and say, I know I know this is a typical long American contract, but let me know what areas you may have as a concern. You've seen the third point. I try to keep a cooperative approach. And if you've done this, and I know some of you on the call, and you have experience in this, you'll agree, it is difficult because we're common law, our contracts are very long and they seem to cover like everything. And if by chance your distributor hasn't seen a U.S. contract, it can be a little bit of an affront. So I kept being cooperative, but I also didn't show my hand. And this was a negotiating technique that I was taught. And I'm maybe a little bit hesitant to say this because it may come off as being a little bit ugly. And I don't mean that in any way at all. But I didn't give anything up without at least indicating that took something to give up. Meaning if they were really pushing back on the amount of time that we needed to change prices. So we typically had 30 days, and they may say that's just unworkable. We need 90. And I may know that I've already negotiated 90 out in other contracts, although typically I would want consistency in something like that. If there's something I'm still negotiating that I know is much more difficult for me, then I'm going to take the approach that both of these topics are important. And that way, when I then give in and say, okay, I'm not going to do the 30, let's move it to 90, but I really need you to stay hold that I'm not giving you both Norway and Sweden. It's just, I know you want it, but that's a deal breaker for me. And so that was just a negotiating technique. Again, a good contract is one that protects both, and it's a compromise between both. I totally get that. I'm just sharing the fact that this idea of not showing your hand is the idea that when you're negotiating, I think you have to appreciate that it is difficult. And if they're really good at it, that's not good either, because whoever you report to is not going to be happy, or your legal counsel may just simply say that's not possible, and now you've really got a problem because you're at an impasse. Who did the negotiating? I always did all the negotiating. And then I was the interface back to legal counsel or to the VP of sales and marketing. So I was European manager in the case of Western Digital Paradise, and I would take the issues back to my boss, and he would take it to legal if that was needed. By the same token, I didn't tend to negotiate necessarily with the president or even owner of the distributor. I was probably still working with the product manager, and certainly not with legal staff, because of course, at that point, you're probably dealing with someone not necessarily with English as their first language, and so that just wouldn't work. I liked keeping it at that level. That's what worked for me. I suppose it also helped that I did a little bit of sharing another aspect of the good guy, bad, or the good cop, bad cop, where I would say, yeah, I can see why you need 90 days for your pricing. So let me work on that, and then come back and say, my boss just won't let me do it. Because don't forget, this is the same person that you're going to be dealing with over the next 3, 6, 12, and maybe multiple years, and that kind of strong relationship is really important. So this issue of exclusive versus non-exclusive. Well, I already admitted that I think exclusive relationships are a critical way to expand your international distribution, sales, and marketing. And it all has to do with how much you're willing to do as the exporter. And I'm just assuming most of the people here are from the perspective of being the exporter or helping exporters, as opposed to what the foreign partner does. And this certainly varies by industry. I totally get that. It certainly varies by the type of product. If your product is more of a commodity, it may simply not be that you want exclusivity, because it works both ways, right? You're not going to get to appoint another representative in that market or territory, and they're not able to carry a competing product. But it really does reward the hard work of the representative and motivates them to put the time and, frankly, expense. I mean, when I'd go to like the Hanover Messe trade show and see a really impressive booth, and I'm like, I want my product in that booth, you're not going to get that same sort of coverage, or it's more difficult to get it, let's say, if you're on a non-exclusive basis. And so my point is, don't be afraid of considering it. When I do my training, I do get a lot of pushback on this, and I certainly get some industries or markets where it just doesn't make sense. But I do think it's really powerful motivation and can be really good at control. But of course, the contract is your protection. So how does the contract protect you? I would think you probably know this, but let's just be clear. First, of course, you're going to specify the territory that you're exclusively granting to the foreign partner. I gave the example of Norway and Sweden. One of the first tips that a mentor of mine gave me was, they may call it Scandinavia, but it's still 4 countries, never treated as one territory. And so I absolutely negotiated 4 separate contracts with each of the Scandinavian countries. And that's important that they know that. Now, they knew that ahead of time, so when I did my initial search, I would say, I'm just looking for a distributor in Sweden. And they would know that, and they wouldn't pitch that they've got capabilities, or if they did, I would know about it. But unless they really had capabilities, say foreign office and a whole nother structure, then that would be different. It establishes the minimum sales levels, the performance targets. So of course, you're not going to sign this exclusive contract without a protection for the exporter that says, unless you achieve on typically an annual basis or a 6-month basis, this minimum performance target, then, and you'll see the wording coming up, then the contract I can choose to terminate it, the exporter can. And likewise, it shows what products, or not so much services, but I guess it could be, that the foreign partner won't represent. So in our case, these were graphic boards and graphic chips and all things to do with computer display. It establishes what they can't carry. And then it also shows the expectations of the foreign partner as well as the exporter as well. So I think even though it might be a little bit scary in terms of what all is going on, I wouldn't worry about lack of control just because you're in an exclusive relationship, because you've got those duties specified and you've got those minimum performance targets. And we're going to talk a little bit about that as well, because that's the next big thing. So how do you negotiate the performance targets of the sales volume? Well, I should start by saying, before I even choose the distributor, in my process of selecting distributors, I ask them to either informally walk me through what the launch of a new product looks like for them, or even more formally, just put together a one-page, essentially I'm asking for a marketing plan, but just give me some idea of what you would do to represent our products in your market. And as part of that, I would also have them do 2 numbers. I would have them estimate the retail price, and at that point I would give them what they could estimate as the selling price to them from the exporter, from our company. And then the second thing I would say is, what do you think the sales levels could be? And I'd ask that of, typically I'd have as many as 4 to 6 candidates that I'd meet with. Now, once I choose the distributor that's going to be our partner, I readdress that whole plan and say, now let's work the numbers. Let's look at what your opening order might look like, what your 3-month sales, 6-month sales, 12 months, and maybe even second year. And that we do totally open. We do it without any criticism. There's nothing binding. It's just us talking to each other, getting to know how we can help each other. How much will I be coming over to work trade shows with them or other staff from the company? What support will be given in terms of advertising or social media work? Meanwhile, what are they going to do? What trade shows? But then when I get to negotiating the performance target in the contract, I back way off. And it always works. So an example, let's say that we think this is $1 million market on an annual basis. Then I'd say, we really believe that, right? And he's like, yeah, I think we can hit $1 million, Jim. I think this kind of market, we've got these many retail stores we're targeting, we've got these sort of key accounts. Then I'd say, well, now we need to put a performance target in to maintain the contract. I don't put that $1 million in. I put something much less. I mean, frankly, I would probably put 600,000 in, which is almost half what we think we can do. Because the truth be told, if they're at 500,000, 600,000, I'm not going to cut them. If I really believe they're working, then I think what's happened is there's something about the market that maybe we got wrong, or maybe there's something about the product that needs to be changed. Maybe there's something about the strategy, but it doesn't indicate that the partner's the problem necessarily. But if they do 100,000 instead of $1 million, if they do 200,000, we know we got a problem. And so what at first was a real problem, my first contracts, we couldn't get past this number because I wanted a really aggressive sales performance target, right? That I could take to my VP and say, look what I got. And instead I said, that's not the purpose of this. The purpose is just to have a back door if there's really a problem. So that was the tips I used for negotiating the performance target in an exclusive contract. Now at this point, if things really are not going well, and we haven't even gotten into some of the other stuff like, you'll see, that's not good. And so if the synergy's not feeling right, then I think that might be a reason to say, okay, maybe this isn't going to work. And you really have to make that decision now, because you do not want to sign that contract. And then probably the earliest opportunity you would have to cancel it is at the earliest 6 months, and it's more likely going to be a year. Now you've tied up the market. It's always painful changing distributors in a market where they've tried to make a name for your product. And then there's always drama around that, what happened, and they want to know what the backstory is. And so this is just kind of a moment just to say that if you aren't feeling as though this is going the right way, now would be the time to walk out. By the way, I saw a question come in about VAT and the level of distributor stockage. Well, of course, normally it was not an issue at all. So, of course, remember, distributors, it's only an issue of cash flow. So distributors don't really, quote, pay VAT. They simply charge it and collect it, and they're just a pass-through. And so because it's not actually, quote, an expense for the distributor, it was never an issue on stocking level. I probably had one or two that did use a bonded warehouse, so then it was really not an issue because it hadn't even come in, quote, to the country. It was just physically there. So no, the VAT was never an issue in terms of sort of the level we needed or how we did the distributor stocking. Okay, so now what are some specific clauses that I want to go through? I want to talk about distributor and exporter covenants and representations. That's where you're going to talk about sort of the expectations, and I've got some examples coming up. How you handle sales terms. For example, do payment terms go into the sales contract? Does pricing go into the sales contract? How long typically do we see as the term of a contract? These two pretty critical issues of choice of law and choice of form. Then the very negative aspect of dispute resolution, but it has to be discussed now while you're negotiating the contract. And then finally, what are some considerations that need to be clarified in the contract as regards to termination? So here we have, unfortunately, some of these really wordy screens, but nonetheless, I think it's critical. And I've only picked just a handful. Some of you, if you're CGBP or you just happen to find the Global Entrepreneur, I wrote a book, The Global Entrepreneur, and in the Appendix A, the whole of the contract that I used is in there. I do put a warning that this is not meant to be copied and then used because, for one thing, it's from some years ago, and second of all, that's not what you should be doing. You should be using a lawyer to develop a contract. But it, I think, is helpful from an educational standpoint, because if you're just starting out and you've never seen a distributor contract, all this stuff's going to be kind of new to you. And so I felt like, why not just share, and so you can learn from it as a way, even though it's not meant to be a short circuit to getting a contract. So an example would be, well, first you'll notice that, and if you've seen this in case of any contract, is that we've long since substituted, you know, the name of the exporter and the name of the buyer and what's being covered, and all that starts out at the very beginning where they go through terms and definitions. And so, of course, it says the distributor, just because that way that doesn't have to be edited every time we do a new contract. All that had to be edited is the very opening clause that says, for the purpose of this contract, ABC Computer Products, Paris, France, will be here to later, whatever, referred to as distributor products. Would be listing maybe in an appendix customer who they're supposed to sell to, and in the territory we will define what the territory is, and then that way we don't have to keep saying Sweden or keep saying maybe it was France and Switzerland, whatever. So you see, it just says, in the case of sales promotion, the distributor shall use its best efforts to promote the sale and use of the products by all existing and potential customers within the territory, and will cooperate. And you'll read the rest of it as well. So you're just sort of clarifying that this is the expectation. I would probably get even, I think it's okay, I should say, to get even a little more detailed about what your expectation is on that. If there's specific trade shows, for example, that you think are important to be in there. We had a level of inventory, just saying that, you know, we're not expecting you to be able to do this and not carry inventory. That's part of fulfilling the sales channel needs by making sure that you're warehousing and not relying on small shipments just because of cash flow. And then there's that clause for performance target. You see, it just says that the distributor will maintain the minimum sales volume in the territory as established in Appendix 1. So that's where I had the figure that we negotiated on the performance target. And then you see it says, in the event the distributor fails to meet such performance target, the company may terminate this agreement by giving distributor written notice of default and 30 days to cure such default. Failure to cure the default within such 30-day period shall, and see it says at the option of the company, result in the termination. So this is actually the instance where, depending on the time frame that you've set up in the performance targets, whether that's on a quarterly basis, I mean, I can't imagine it being any shorter than quarterly, or 6 months. Mine were 1 year. That worked for our industry, and it certainly worked for the first year, because the ramp-up time of launch and training and media and social media just took well, it didn't take a year, but I mean, it took more than just a matter of months. But there's that point that you then have to be proactive in notifying that they are in default of that performance target, and then they have 30 days in which to catch up on those sales. Let's look at another example. Again, this is from the standpoint of the distributor covenants. So these are things that the distributors expected. Coming up after this are things that we expect of the exporter. Well, of course, you have to deal with things like aftermarket support and service. And again, these are just examples. There's many, many, many distributor covenants and representations in a typical contract. And this is just showing that we are expecting, this is the whole idea of managing expectations. We are expecting the distributor to do the aftermarket support and even listing their installation, inspection, testing, and customer support. That's not something we're saying in a exporter covenant or company covenant that that's something we're going to do. You'll see what we have to do. They will also assist in warranty and maintenance and repairs. And so you're just setting these expectations out. Another example is we move now from the exporter, which in the contract is listed as the company. There's also lots of expectations there. So here, the first one, for example, sales support, shows that the company's going to be making sure that they're going to get all the information that's needed to the company in order for them to be effective in their sales and marketing. So for me, for example, that's all my line art, my digital art, my logos and high res, is sample products, empty boxes for displays. It's just showing that you're going to support this relationship as needed, and you're listing those things out and whatever's appropriate for your industry. Also, what about changes? The company shall notify the distributor in writing of any changes in or affecting the products or price, terms, and conditions of sale. And there's that starting with that 30 days. And that is something that I typically got pushback on. And I get that. That 30 days came from our domestic market, where I think that's appropriate. I do think internationally that might be pushing it, but I don't think you can go much more out than, say, 60 days. And I don't think I've ever seen anything greater than 90 days. Because I think product life cycles and just the way supply chains work these days, you've got to be able to respond quicker than that. And so I would be uncomfortable doing much more than that, but that gives you some idea. Another example is assistance. Companies shall provide the distributor with reasonable access to and assistance of, and now it goes into technical things. But it does show what expenses. So it says that there's no assistance that's going to have a charge to the distributor exclusive of travel expenses. So if something comes up that they're saying, we really need to do a new training event for our staff. I know you did the first one that you promised, Jim, but I think another one, now I would probably work that in and not charge them anything, but it all depends on the industry. We have a client here. I'm with an Illinois SBDC International Trade Center at Bradley University. We have a company that makes really fine computer-controlled logging equipment, and they include installation and training, and they're selling all over the world. But the expectation is that if that didn't work the first time, they typically will pay or charge, I should say, travel to go back, because that could be a $5,000 or $6,000 trip, and it might not result in necessarily new sales. Just shows an example of training company shall conduct. Shows just examples of the training, very legalistic. I would probably, again, looking in hindsight at this contract, be a little even more specific in terms of how often or how much that would be. So then sales terms, another example of a section within the contract. In general, you don't want to put in the contract things that are going to change. So I didn't put the price list at all. I just didn't see the value in having it, because I knew that I've got my protection, that I can change the prices in typically 60 days. So I do think we just included it maybe as an appendix just because it was like a starting point, but I just don't see a critical need for it. And the same with payment terms. We all know payment terms are going to change over time, especially if you're starting with prepayment. And then you'll probably move to collections, or maybe you're starting with letter of credit and then you move to collections, or hopefully you eventually get, or sooner than not, get to open account backed by Ex-Im Bank foreign receivables insurance. So with that in mind, there's really no need to have that in the contract. But you do want to put things that are going to always apply no matter what's happening. An example would be that all freight terms or all quotations under this relationship, this contract, are subject to Incoterms 2010. You certainly indicate when the price change can be done, as we saw in the prior clause. You might say, and this is actually copied directly from the contract, quote, for warranties, all sales to the distributor shall be subject to the company's standard warranty as contained in its terms and conditions of sale in effect at the time of shipment. And I never got pushback on that. And so what that meant was, if we launched a new product that had we had a disk drive product. When we launched that had a slightly different warranty setup than we had with some of our chip products. And so there was no need to go back and change the contract, because It just simply said the warranties are associated with the product and the conditions of sale at the time shipment is made, and has nothing to do with the contract. So that's the idea, is that we're putting in here things that will apply, but then those that are constantly there, such as warranties, we're stating that that's a concern, but we're offloading the actual warranty itself to a separate document. Let's get to the issue of term, because this is always a little bit difficult as well, the term of contract. Well, obviously, the shorter contract favors the exporter. I mean, in general, you want to know sooner than later if this is going to work out or not. And if it's not going to work out, you don't want to be tied up much longer than you have to, right? So I suppose I could be criticized for this, but I pretty much always got a one-year contract from my distributors. And they didn't push back. They should have, because this is not protecting them. The distributor is going to probably open with a 3-year request. And I don't know, I guess just by walking through the issue and saying, let's talk about this, don't you think that after 1 year, we're going to know whether this is working out? It's going to be easier for both of us. I can see going to a 2-year, that would probably be my compromise. I'm not sure I would go all the way to 3 unless this is like, wow, this is a distributor I've been working to get. I can't believe they want to represent us. They're like the really great distributor who has the really big booth, you know, with the 2 stories and the refreshment center on the 2nd floor with the lounge and everything. It's like, this is the company I want to be with. That, then I might see a little bit longer, and I'm partly joking there. So you have to think this through, though, because it is a critical issue, because this determines, remember, breaking a contract is very unusual, even just based on performance targets. So I have had contracts with a minimum performance target that they absolutely missed, and I still didn't break the contract because I knew it would be more painful to change distributors than to try and fix the problem. I would certainly go, I mean, maybe do an extension of 6 months and just see where it's going, or I do more intensive training or more intensive sales and marketing. I do something to try and fix it, because I'd rather stay with someone if I think they've got the potential than if maybe things have all gone wrong, the product manager left and they brought in somebody with less experience, then that's completely different. So that's why I'd say 1 year is not that uncommon. 3 is probably the longest that I would recommend. And another tip, we never had auto renew contracts. So it always took the exporter or company, they had to explicitly say with a 30-day notice that they want to renew for a successive term. And I think that's a good idea. I don't like the idea of auto renew. People forget, and next thing you know, you've blown past that period, and you've now got a whole nother year, and maybe you really were intending to at least talk about that this wasn't working out. Now we go to these issues of choice of, well, let me stop and see, are there any questions? Because now we're going to get into a couple of really kind of difficult stuff, although it's not that tough, to be honest. But if you've got a question, go ahead and jump in on the chat, and I think I will see it. Or let me hold on, because if you send it privately to Lisa, I won't.
Yeah, if they send it privately, you won't see it.
Okay. And that's fine. However you want to send a question, either send it to Lisa privately, info@nasbite.org, or, and that's probably just as easy. We'll see. We've got quite a few on the call, so whatever makes sense.
Yeah, they can send it to the chat. We'll see it.
Okay. So let's go on then. Choice of law. This is a CGBP question. Choice of law establishes what countries' law are to be used in order to understand, in the instance of a dispute, what's really going on here. So an example, this agreement, so this would be a clause in the contract, right? This agreement shall be construed, enforced, and performed in accordance with the laws of the state of Illinois, United States of America. You don't just simply say a country, because as you know, laws here vary by district, by where where the choice of law is, where the place has been determined. I say this is a little controversial because this is kind of a big deal. Whose law is going to apply starts to become really obvious in the case of a dispute, because you may not yet be at the point of a lawsuit, but something's not going right. And some part of the clause, you're saying that that's been violated, or they're saying that it was violated by the company, by the exporter. Well, but of course, the question of whether something has been violated is a question of law. And you can't answer that without knowing whose law is interpreting whether that is a violation of the contract or not. And so this has to be declared. Now, I always got US law as the choice of law. Now, I think that's because in most cases, we were the much bigger company than the distributor. Second of all, I was in the computer industry, and the US was like a leader in that area, so they didn't question that. I also think it's not horrible law, meaning my experience since then is that there would be some companies that might even choose, even though they're not US based, possibly could choose US law, because there is so much clarity, given that we're a common law market. There's so many precedents that we know what something means when we ask the question about that. I actually think, though, what mostly happened is just that they knew it was a Yank and an American firm, and the chance of getting that choice of law switched to France or Germany or Spain just wasn't going to happen. But I say this a little bit in jest because I was talking to a company in Canada who is in the middle of a dispute through their partnership agreement, their contract. And now the Canadian firm is really regretting that they allowed the choice of law to be the US, because it just did not go well, and they felt that most of it was that their hands were tied to a choice of law clause that declared the US, and I can't remember what district or state it was. And in fact, and this was a lawyer then who was actually giving advice, who then said, you know, if we couldn't have gotten Canada, I would have taken the UK over the US as the choice of law. And in fact, I found some research in preparing for this webinar where UK had actually come up as an example of a third country that might be listed in cases where people were not comfortable with their own domicile country to be the choice of law. Now, this is really, really, really something that absolutely cannot be done without legal counsel. So you're going to see that if you go and get a US distributor contract for international distributors, they're going to just, I'm pretty certain in 99% of the time, they're going to put automatically that the choice of law is your city or district and state where you're based. And I never got pushback, but if there is pushback, that would definitely be something that I'm like, now that's a really big issue for us. I can't even comment on it. I'm going to have to take that to legal counsel and see if there's any chance. And at least in our case, I don't think there would have been a chance that they would have accepted anything other than, in our case, it was California. Similarly, there's the jurisdictional clause, also known as the choice of forum clause. This determines, in the case there is a claim against a party, what jurisdiction, what court would you actually file that claim? So as an example, this comes straight from the contract. All disputes arising between the parties concerning the validity, construction, or effect of the agreement, or the rights and obligations created hereunder that cannot be resolved voluntarily by the parties shall be decided by the United States District Court for the 4th District of Illinois. So you're basically saying, if you're going to have an issue here, you're going to have to file that claim as named in the choice of forum. And I would think in most cases, your jurisdictional clause is going to list the same location as your choice of law clause. There is also what's called exclusive versus non-exclusive jurisdictional clauses. And that would be, if it's exclusive, then that means that's literally the only thing they can do when there's a claim. If it's non-exclusive, they could still make a claim in another country, but at least for the purpose of the contract, that would have to stay within the jurisdictional clause. Now we're going to go next to arbitration, and I want to point out that if you're using our arbitration clause, which is, as I understand it, and I haven't done this as a survey, arbitration is becoming a, let's say, popular or an accepted dispute resolution method as opposed to litigation. So, and we'll come to that. But if you have arbitration for your dispute resolution, then you probably are not going to have a choice of forum clause, because the whole purpose of arbitration is that you're not going to file a claim somewhere. Instead, you're going to go to arbitration, and we'll come back on the slide with that. But I see there's a question. What if the choice of law rules in Illinois would choose there and not here? I'm not sure I get exactly the question, but I have a feeling the question would be, would I choose a choice of law that's not necessarily where my company's based in the case of the US? And that's really a good legal question. I actually think that there is a chance that you would, that there may be some instances where a lawyer might say, just like you may not incorporate in your state, there might be a court where you say this is for the choice of law because that state happens to be, for your industry and for what you're trying to do, a better situation for international disputes than your own. So I would think that might be an example where the choice of law could be different. So then moving to arbitration. So again, arbitration is a way for dispute resolution. So typically, dispute resolution, we're talking, of course, here about when there's a problem, when someone's upset, when they think that they've been wronged, when they've not upheld the duties as specified in the contract, and then we have a dispute. Obviously, the first thing that happens is we just talk about it. And so that's why the first route of dispute resolution is just negotiation, talking. Go have a cup of coffee or get them a good German beer or something like that, right? But at some point, it gets to be more formal. And the advantage of arbitration is that it's less expensive than litigation. And we can all imagine that litigation, no matter what happens, is going to be expensive. And don't forget that in some countries, depending on where you've set this up, if you lose, you may be liable for not only your court costs, but the court costs of the distributor. So litigation can be a tricky issue. So arbitration, instead, you put a clause, and there's the one that would not be uncommon. In fact, that I pulled off of the International Chamber of Commerce. All disputes arising out or in conjunction with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with said rules. I've put the website because if you're thinking at all about using arbitration, there's some great tips that the International Chamber of Commerce provide. You're going to see a few of those coming up. They're by far not the only arbitra organization. There's actually an international organization of arbitration that you could go to. But the idea is that it needs to be neutral. So you're not going to appoint someone who's in the distributor's country, and maybe not even in the US unless it's an international organization. I mentioned they have some tips that I thought were kind of helpful. They say to make sure that there is the law governing the contract, so that's your choice of law. That makes sense. You can say how many arbitrators you'll actually be using in the case of arbitration, where it should occur. And I found this interesting and obviously very good from an international standpoint, the language of the arbitration, so that you clarify that the arbitration needs to be conducted in, and probably if you're a US company, based in English. So now we come to the last question of termination. Now, generally, you're going to terminate if either party does not perform any of the duties after a 90-day notification. So if there's something that's grossly gone wrong in terms of one of the covenants, then there's a 90-day notification. Let's say they're not warehousing stock at all. So they've gone, 2 months, they're keeping no stock, and there's just no way they could be fulfilling that covenant. Then after a 90-day notification, then you can terminate. And these are just a few. If you ever look at a contract, there's probably 7 or so, or there's a number of clauses associated with termination. But another one would be that it is terminated immediately if there's a significant event, like bankruptcy or receivership, and that typically applies to both parties. If the distributor sold, now our contract didn't say, and also if the exporter was sold, and funny enough, we were sold, we were first separate and then sold to Western Digital, but because I didn't have that, none of my contracts had to be renegotiated. And then of course, if the distributor fails to reach the minimum performance target stated and not remedied within 30 days. But some other issues associated with that, you have what happens if it is terminated. So if for whatever reason, we know this has to be terminated, we've successfully terminated, then what does that mean? Well, you typically state in the contract the expectation, for example, that the distributor will absolutely stop doing everything, all sales and other activities. And this is kind of interesting, including notifying any government entities. So of course, in some countries, a distributor will register if they're the exclusive, or they'll register the contract even of a company, and they have to notify them that that's no longer the case. This clause, of course, I got pushed back on, and all outstanding debt is due immediately. That'd be an easy one to say, okay, we'll keep it with the standard payment terms. So if I'm open account 90 days and I terminate them, I'm just going to assume that they'll still get us paid. But the contract would say that they had to, that of course they'd have to remove all trademark markings, any activity like that. And then this was always tricky. What do you as the seller have as an obligation for any inventory that the distributor may have at the time of termination? Our clause was always that the exporter has no obligation but may purchase any inventory, and critically, of the distributor at current prices. In case there's been a big discrepancy, it could go against you in that regard as well. So, final thoughts, and then we'll make sure if there's any questions that are out there. You absolutely need to get good legal counsel, and it's not as expensive as you'd expect. You know, I guess I see this a lot from trade assistants. They're like, oh, I don't really want to use a lawyer, and that. This is common stuff for firms that have experience in this area. And don't forget, they probably have a template that they have used, and they're gonna sit down and make sure that it fits your needs, but it's not like creating something brand new. I'm just finishing the next edition of Global Entrepreneur, but this is actually true for the prior editions as well. So if you want, you can really cheap pick up a used copy on Amazon. You can see an example of the contract, but again, that's just for educational purposes. The other thing is, it would be a whole nother webinar to talk about laws in foreign countries that can impact a contract. And those are really important as well, because the rights that distributors have here in the United States are a lot more limited than other countries, where in some cases terminating a distributor relationship almost feels like terminating an employee. So don't forget, there's other foreign laws that you really have to take care of and be aware of. And then a little motivation, stay calm and use the process as a way to strengthen your partnership. And that's really true. I think this process of negotiating the contract, just looping back to the very beginning of the webinar, is really the first big task that you have. And I think see it as an opportunity to cement that relationship, which is why I say if it's all going wrong, then that might be a need to think about walking away. Well, with that was a kind of pretty quick dump of information. Those are at least my thoughts of what the task looks like when negotiating a contract with the distributor. Many of those principles would apply in the case of agents and representatives. I hope it's at least helpful. And Lisa, I think we certainly got time for some questions.
Yeah, everyone, if you have questions, please go ahead and submit them now. But in the meantime, we just want to thank you, Jim, for coming on. Very great presentation, very informative stuff. So yeah, go ahead and submit those questions. And we just want to thank you guys for attending the webinar today. If you do come up with a question, please go ahead and send us your question to info@nasbite.org, and we'll make sure that we get that answer for you. Our next webinar is going to be on August 2nd, and we actually will have 2 webinars in August since we missed one in June. The first one will be August 2nd. The second one I think might be August 15th, if I'm correct. But either way, registration will be opening for those very soon, so definitely keep a lookout for those. Oh, and the topic for the August 2nd webinar is going to be Fulfillment by Amazon, the logistics of importing and exporting through the world's largest online platform. So it should be a good topic. All right, Jim, I'm not seeing any questions. Oh, okay. Question just came in, Jim.
Okay, what if they refuse to arbitrate? Well, that's the whole idea. They can't refuse to arbitrate. That's why you have to make this decision at the time of negotiating the contract. So when you sign the contract stating arbitration will be used, then they have to use arbitration. Obviously, if they, I shouldn't say, then what happens if you're literally saying that even though they agreed to arbitrate, but then there's a problem and they refuse, you should be protected by the rules that you've set in place based on the arbitrator that you've selected. And I think you would find that the rules, such as ICC, would say, then you've won the arbitration and you could then get a claim, and that would be legally binding, and that claim could then be filed. And if it results in money, that means they would now be legally responsible. Remember, arbitration is also, I had to be careful here. I don't want to say things that sound like a lawyer. So that would be the thing, that you've got the rules of the arbitration from the arbitrator that protect you, so that they literally they refuse to arbitrate, then you've got that protection.